It's not just equipment, folks, where somebody drops a dumbbell on themselves or trips or falls on a treadmill. You can get sued and get yourself into some legal trouble, even with class instructors, which we're going to be going over today. What do you say? Let's get into the fun part. Let's go over some case studies.
All right. Well, I have here a list. I hope you don't mind if I refer to some of my notes along the way as we go. But I have 10 different types of group exercise classes where there have been negligence claims made against the instructor and or facility or the gym owner. So let's go ahead and get started. I'll start with indoor cycling. And in one case, the instructor failed to instruct a beginner on how to use or adjust the bike. And so when she stood up into a standing position, the handlebars dislodged, and she fell forward while her feet remained strapped in the pedals. So she suffered very severe back and neck injuries. So let me give you what happened in that case. There was a negligence lawsuit against the instructor and the club. And interestingly, in that case, there was ordinary negligence. And I know we've talked about the difference between ordinary and gross. Ordinary negligence, a waiver, if it's legal in your state or jurisdiction, will probably protect you if it's written properly, administered properly, and so on. In gross negligence, remember, the waiver will not protect you from any negligence. So in this case, the court ruled that it was ordinary negligence. The waiver was well written and well administered, and it was legal within that state. And so there was the fitness facility was not found liable. The waiver actually protected them from any kind of liability. So that's one case with indoor cycling. Another one, this was an instructor who allowed a beginner to come into an advanced indoor cycling class. And it was a high intensity class. And unfortunately, this participant ended up with exertional rhabdomyolysis, a very serious injury. So that's what happened in that case. And we don't know the outcome of that case yet. I could not find an updated. It was going to go to trial, and I was not able to find it. A lot of times trial court opinions are not published, and so we don't really know what happened in that case. But I can tell you that with indoor cycling, just because it is, and I think we've talked about this before in one of the other podcasts, it's usually a pretty high intensity class. And with a beginner, and you have a beginner participate, let's say in a 45-minute high intensity class, there's a risk of this exertional rhabdomyolysis. So there's been several cases of exertional rhabdo with indoor cycling. I think I had mentioned before, I was an expert witness in one of those cases. And the plaintiff, the injured party, it was settled out of court, but for a very large sum of money. Okay, so there was a large settlement in that case. So again, I know we talked about the importance of having beginner classes, and this would be a really good type of class to have a beginner class, an indoor cycling class for beginners, because you want to provide them with the proper education and the training, and supervision, and making sure they're not overexerting themselves, doing something that's too intense, too fast, too soon, all of that kind of good stuff. So anyway, those are a couple indoor cycling cases. So let's go to a boot camp. Boot camp has been a popular exercise program for several years. And this individual was severely injured when a 400-pound, get this, a 400-pound tire fell on her foot, crushing her ankle. And she alleged that the instructor and the gym should have known about the dangerous conditions associated with the very heavy tires and the overcrowding too of the class. So in that particular case, again, this is one that's pending, but she's suing for $2.5 million. So that's a lot of money. And so again, she claimed that this crushed ankle resulted in a disability. She was really having trouble with walking and that kind of thing. Mm-hmm. So that's the boot camp case. So let's go to a yoga.
Wow, that's surprising. Yoga.
Yeah.
Wow.
Oh, I tell you, there's a lot of injuries in yoga classes. Some of the research that's been done just to survey, injuries in yoga classes, there's a lot of musculoskeletal injuries. And most often it's because they're having individuals, again, like beginners, performing advanced poses, advanced exercises, and they're not ready to do it. So they end up injuring themselves just because they're not ready for those higher level or advanced poses and techniques.
Wow.
I was injured in a class because the lady she pushed me into position. Speaking of, so I did get injured, but I was younger. This was a long time ago. And I just feel like you shouldn't manually cue somebody because she had moved my hips back and it hurt my back so bad. So anyway, like you said, it was like bone related too. And I hurt my back so bad afterwards. And I remember I couldn't kind of walk for several days. When I moved my hips back, she like shut down when we were in like the child's pose and put her hands on my. So anyway, I don't know if you have any recommendations for that too when we go over it, but I think manual cueing is another thing group exercise instructors have to be aware of. So
yeah, I'd agree. Sorry to hear that you had such an injury. That's too bad.
I mean,
The first case I'm going to talk about is similar. This participant, she was severely injured, claimed that her yoga instructor was aggressive, injured her neck when she was adjusting her posture. So again, to manual manipulation. And so in that particular case, remember with negligence, the injured party has to prove first that there was a duty, The defendant, instructor, and the facility had a duty, and they have to show there was a breach of duty, and then that the breach of duty was the actual cause of the injury. So there's got to be that link between the breach of duty and the injury, In this particular case, the plaintiff was unable to show all four of those elements of negligence, The court said there was really no breach of duty and that maybe her neck injury wasn't really due to that particular instruction, but she's unable to prove it. So you got to prove, breach of duty caused the injury. So that's where that case didn't go anywhere then, because the negligence wasn't proven in that particular case, which is interesting. But to get into these cases and read them, they're so legal, just very technical. The language that's used, verbiage, understanding the verbiage, and they analyze these cases from all of these different perspectives. So it's really hard to get into all of the reasons why the court made the decision they did. Otherwise, you'd be here for weeks going through maybe one case just because they're so detailed. But anyway, in that particular case, she just wasn't able to prove the negligence. It's
surprising that yoga, sorry to interrupt, but it's surprising to hear yoga because a lot of owners like that open gyms that have classes for free to try to entice people to come in. I don't even think most of them would take a second guess that they could get a lawsuit from their free yoga class they're giving away more than, the equipment. So I have a quick question before we get into the next case study. Say I own a gym and it's a regular gym, treadmills, weights, everything, but I also have classes as an amenity if you become a member at my facility. And in those classes are yoga, cycling, typical classes. Do you think me as being an owner that I usually have you sign my gym membership, which has a waiver, but because I'm having classes, should they have like a separate waiver because I'm doing classes as well?
The waiver really should cover all activities that are provided with the facility, include, usage of all the equipment, the locker shower areas, all of the group exercise classes, personal training, would have a waiver that's well written that covers all of the activities that you provide. And that is really important because I'm glad you brought that up, because sometimes the waivers have not been complete. They have not covered all of the various activities that the gym offers. And so you really want to be sure that your waiver, again, the good, competent lawyer, and communicating with that lawyer, all the things that you provide in a facility and making sure that that is listed in the waiver statement. Yeah. Now, some clubs I know have had kind of this general waiver that covers everything, but then they also have maybe a waiver for personal training. So it's just another additional waiver that probably gets into more specifics in describing the personal training services. And so I've read several cases where some facilities might have both. In that case, I haven't seen any that have had a separate waiver for Group X But basically, you would want to cover it in your overall waiver.
Okay. And one more question, because I'm envisioning if someone's listening to this, they're probably like, well, what if this while you're doing a case study? So I'm trying to ask questions as if the listener had the chance to ask you a question. You mentioned before that case study where person got sued because they were a beginner going into a class. In your best opinion, what would be the best way to prevent that? Should that just be a notice on the class when people are signing up for that class, or while somebody's signing up, ask the person if you're going to be taking cycling, make sure that that be in their instruction set at sign up? Like, would you say would be the best way to prevent that from happening?
Yeah, and that's also another really good question. Of course, I always recommend that the fitness facilities and the gym should have beginner classes. And if you have somebody that's coming in and they sign up for class, say indoor cycling, you would recommend that they take the beginner class to start with. Now, maybe they can't always do that. It's not offered at a time that's convenient for them. So the other option to that would be, okay, you're a beginner. What we want you to do is to come 15, 20 minutes prior to the class, and our instructor will meet with you one-on-one to go over the basic instruction, how to use the bike, et cetera, have them sit in the front row. I remember one case where it was a beginner and they said, oh, just go sit in the back and just follow everybody in front of you. Okay, well, first of all, if you've ever been in an indoor cycling class, it's dark. The music is really loud. And I don't know really how the instructor even can observe the people in the back adequately to watch for signs and symptoms, for exertion or not performing the exercises properly, whatever it might be. So I would encourage them to sit up front. As the instructor, I would be monitoring them very carefully. I would give them instructions. Okay, I don't want you to do the standing up. When you stand up, that increases the intensity of the exercise. Even though other people in the class are going to be doing that, I would like you to stay in the front so I can watch you and help guide you a little bit more on maybe some specific cues to follow, as you're starting out in an indoor cycling class. I would have the gym owner or the group exercise coordinator prepare kind of a checklist of everything that they go over in that 20-minute instructional period before class. Have a checklist of everything that's covered, and then sign off on that and keep that document to show and demonstrate that they did provide instruction, okay? A lot of times that's the negligence claim, is that the instructor did not provide proper instruction. But here you have a document where you went over ... where you provided that really important instruction for day one in the class. And that could be done with every type of class, not just indoor cycling, for all beginners. And does it take a little bit more time for the instructor to come early and do all of that? Yes, it does. And the instructor should be paid for that time, in my opinion, and be very helpful. And I think most beginners would appreciate that one-on-one kind of instruction.
And to most people, if they're listening to this, be like, oh, that takes a lot of time. How am I going to say that? Just keep in mind, Gym and Site software, you could have that checklist on that customer's profile where anyone can check that off and it's saved on their profile. So if a case should happen, you can easily pull that up. That person went through this class and was told the right way to do things, and you've protected yourself. Okay, thank you for answering that, because I'm trying to ask questions. Listening to you, I'm envisioning myself as an owner that is saying, okay, look, probably if I just heard that, I would ask this. So that I apologize for interrupting for next case study.
No, feel free to do that, because I think that's really important to think through the questions that some of your viewers might have. Go through these. The other one, the yoga, the instructor exceeded the customary force to place her in a yoga pose. So again, having the person do something that was maybe too advanced, and that resulted in a neck injury. And then she also claimed that the instructor paired her up with an individual who was a lot stronger than her. And so like a lot of times when we pair people up to do exercises, I think it's important for the instructor to make sure the partners are equal in terms of their ability and size and that kind of thing. So what happened in this case, instructor in this case, the big issue, and this was kind of convoluted case, but The big issue was the instructor an employee, an independent contractor? And so after a lot of discussion on this within the court's opinion, again, very technical summary of what was going on in this case, the court basically said that she was not an employee, that she was more likely an independent contractor. And if you recall from some of our other podcasts, we talked about vicarious liability.